answers at the very end. We're going to turn off the recording, so you don't have to worry at that point. You can ask your questions freely. And we're also going to get a little bit of an update about what's going on in the community with the eviction crisis more generally, and also how MAID fits into it. So you'll be able to hear and hear from some of the experts who are dealing with that, and also be able to share some of your experiences a little bit. As we're going through today, we're going to try to use the chat feature because we have a very large group in order for people to raise their questions and comments. And we're going to set aside a generous amount of time to go through those at the end. If there are some points where, excuse me, where your question's relevant right away and we know we can answer them, then Molly, who's doing the moderation for today, is going to surface those, and we will address those right in context too. So just jump right into it. And first, I wanted to let everybody else who's on the call, who's part of our team, introduce themselves a little bit. As I said, I'm Quentin, and I'm at Suffolk University Law School's Legal Innovation and Technology Lab. And Annette, if you're on, if you want to introduce yourself.
Sure. Annette Duke from Mass Law Reform, and I just want to say I'm really happy to have the dream team that you're going to hear from, Quentin, Stephanie, Jade, and Molly, and it's so good to see everyone, so many familiar faces, and hopefully we can turn MAID into some advocacy too at the end. So welcome.
And we'll just go down. Jade, if you want to introduce yourself.
Hi, I'm Jade Brown. I'm at Boston University School of Law as a clinical instructor, and I formerly worked in the housing unit at Greater Boston Legal Services.
Hi, everyone. Good afternoon. If that's what time it is, we're in a weird time where there is no time. My name is Stephanie. I'm at the Justice Center in Brockton, a subsidiary of South Coastal County's Legal Services. I'm originally from Panama, and my first language is Spanish, so I'm excited to tell you how MAID has so many different languages and capabilities for English as a second language folks, such as myself. Welcome.
And hi, good afternoon. I'm Molly. I'm a housing attorney at Northeast Legal Aid, and I'm moderating the chat right now. So if you have any questions, just feel free to type them and I'll be looking at them. I'm happy to be here today.
So I'm just going to jump right in now to a little bit of a background of what MAID is and how you can use it in your work. MAID is what I like to call a self-guided clinic in a box. So what does that term mean? It means that what we're aiming for with this tool is that it replaces the experience of being in an in-person housing clinic where someone is working on responding to an eviction case. So specifically, we're helping a tenant fill in up to 7 different forms. The key ones are an answer form and discovery form. And we'll explain a little bit more about what those forms are a little bit later in the presentation. And it will help somebody, not just if they're going through the normal scenario where they're at the beginning of the case, but if they miss their first court date, it will help them file a late answer to. And I expect that's going to be something that's important in the immediate post-moratorium surge that we're expecting to see. The way we designed this tool was thinking first and foremost about pro se people and what their needs are, people who do not have an attorney with them. And then after that point, thinking about what are ways we can use this inside our eviction clinic. So I designed this tool and built it a few years ago. I used it for about 2 years in eviction clinics at Greater Boston Legal Services and helping people one-on-one at Rosie's Place, which is a shelter in downtown Boston. And my goal was to make it easy for me to use, but also so someone could use it who I wasn't helping. The other you can find out. We need to there. Thanks. So we thought about language, literacy, and disability as one of the key things. So MAID's available in 6 different languages. It's available and designed to meet a 6th grade reading level, so using what we call plain English. And we thought about people who have disabilities too. So the whole website is accessible for screen readers and includes a text-to-speech feature that's built right in as well. The obvious reason why this is relevant right now is because of the COVID-19 crisis. MAID's a tool that you can use safely at a time that courts are closed, when you don't want to go into court in person. And we expect that for a long time, courts are going to be remote first. And this is a tool that you can use completely on your own, as I said. We've turned what could be really complicated legal questions, like here's one, for example, that answers, is the service that I got from the landlord defective? And it breaks that down into fact-based questions that a tenant can answer on their own. But for most of you here, I think you're interested in solving this question, which is how do we get from what we used to have in terms of face-to-face conversations with our clients, sitting across a table maybe, helping them and providing them guidance when they're working on a form like this, and how do we do that in the COVID-19 era? So that is a workflow that is really right up front and center inside the tool that we've built. Using a smartphone, a tenant could be working on the form, and an advocate can be at the other end helping them along the way. Or that could be the reverse way. A tenant could be talking on the phone to an advocate who's filling out the forms, and when it's ready for the tenant to add their signature, then at that point, the advocate could send the link to the client to sign, and then the client can send it right back, and then be able to print and deliver it to the court. For right now, that is still a really important consideration. That's probably the barrier the tenants are going to have the most, which is how do they take this form that they've just filled out on their phone and actually get it to the court when at time the courts are closed. One answer is to call the clerk, and they may be able to help walk somebody through that process. I think as the court starts to reopen more and more, it still may not be safe for tenants to do that. And the court clerk may not be willing to help somebody over the phone. So that is where you as an advocate can make a really big difference, helping them get that paperwork. We also are in talks with the court, and that might be part of the advocacy piece that comes a little bit later in our presentation, to figure out other ways to do this so it's much more seamless for a tenant. For those of you who are not lawyers and who don't already practice landlord-tenant law, you may be wondering, well, why is this even something that I should encourage my clients to do? Why should they be filing an answer in discovery? And is this process worth it? An answer is not mandatory in an eviction case, but it is a very important step to do. So one of the main reasons is because it gives your client a chance to tell their story to the court. MAID helps them tell that story in a really digestible way that's understandable for a judge and for their landlord. So they'll have all the facts and all of the possible defenses and claims that they have against their landlord laid out so they're easy for a judge to understand and to decide if they met the standard for getting that defense. It's important to file discovery as well, because this is a chance for you as a tenant to learn more about your landlord's case. So that's something that tenants have a right to do. They have a right to get that information, and only if they file that before the case is heard in court do they have that right. And sometimes that can reveal really important reasons why you shouldn't be evicted. Last really concrete reason is time. If a tenant files an answer and a request for discovery, they automatically get a 2-week continuance from their original court date. So that gives them time to potentially find a lawyer to work with them. Sometimes those 2 weeks are all that they need to solve the problem that created the eviction risk in the first place. They might be able to find money to pay back rent, or they may be able to find a soft landing for them somewhere else, a different apartment. This tool in particular, I have found through my experience helping people one-on-one at Rosie's place, I would generally take about 20 minutes to help a tenant from start to finish. It could definitely go longer depending on the person's needs. And even with the language accessibility features that are built in, there's still does take a bit longer when you're dealing with someone who speaks a language other than your own. And if a client is working completely on their own, I've seen this as well. That's how we ran our clinics. Some of our clients who walked in, some of the tenants, would take as little as 30 minutes. Some of them would take longer. And that's about the right range for them to expect to take. But all of that time is self-guided. So they can be doing this on their own. You can be helping a lot of people at once who you can check in and assist with without having to be walking them through each step of the form. So I'm going to turn it over now to Jade, who's going to tell you a little bit more about the training portion of this. And Jade, I don't know if you want me to still run these first few slides.
Hi, everyone. Yes, Quentin, if you could still go through the slides, that would be great. So in order to use MAID, it's really helpful if you can gather some documentation from your clients initially. So one of the things you would want to gather is what's called a notice to quit. So that's a document that the client would have received that tells them that they're being evicted or that they're going to be evicted and the reason why. It might say something like non-payment of rent, or it might say for cause or no fault, meaning the tenant has not done anything. They would also have received a notice from the court called a summons, and there's a sample copy here. I don't know if folks can see it, but the summons is the notice from the court telling them, you know, that there was a case filed against them. It tells them when they have to go to court. It also tells what the landlord is alleging the reason for the eviction is. So it would also say non-payment of rent or cause, and also that it specifies the court that the tenant needs to go to for the case. And okay, so one of the great things about MAID is that once you filled out the documentation online, you actually have the option to sign those forms electronically as well. So if you're filling it out with a client, you could put in the client's phone number or email address, and it would send a copy to the client for them to sign, and they can do that either on their computer or on their cell phone. Okay, and then the third part is that the great thing about doing the electronic answer and discovery is that you can also e-file it as well. So you could go to the court e-filing system that's called Tyler, and either you or the tenant could file the documentation into the case. They would still have to mail a copy probably to the landlord or the landlord's attorney, but at least the filing would not require them to physically go to court or to mail it in. Okay. And, now I'm going to switch over to actually showing you what MAID looks like and going through a quick demo of the system. So I'm going to try to share my screen. Okay, so I'll actually start off by showing you how to get to the MAID website. So if you go to gbls.org/MAID, I'm not sure if folks are seeing the new screen.
Seeing Jade, yep, we see the Get Legal Help page there.
Okay, great. So you go to gbls.org/MAID, you'll come to this page. At the very bottom, it'll give you these options. So you can actually start an interview, and that's the option that I think is gonna work for everyone. So you wanna hit start an interview here, and it'll bring you to the main page for MAID. The system gives you these small video tutorials throughout that can help you if you hit a roadblock. But basically, it gives you an overview of the timing that it's going to take and the documents that you'll need, again, the summons and complaint and the notice to quit. So let's see if we started a new interview. So the first thing it's going to ask you is whether you are a tenant, someone helping the tenant, or an attorney. So for this exercise, we're just going to say tenant or helper. And it sort of gives you an overview again of what this interview process will entail. So it's going to ask you some questions about the landlord, about the tenant, about the apartment, and any other factors that might be affecting the tenant, such as whether they have a disability or things like that. And here you have one of those helpful videos that I mentioned. So this is something that you can watch to just get a further overview. So one of the critical questions that I ask is sort of, do you have an upcoming court date? So if you have a court date, or if the tenant has a court date scheduled, you'd want to select, I have a court date scheduled. If there's no court date scheduled as yet, then it's not at that stage, it wouldn't allow you to file an answer because there's no upcoming court date. It might be a little bit different right now with COVID-19 because folks may have had those court dates pushed out. So if the tenant has their summons and complaint and there wasn't a court date on there, even if that court date was rescheduled, I think you want to put in MAID that you have a court date scheduled. Okay. So now it's going to ask you for some information about the tenant, so their address, and whether this is the address that they're being evicted from. This is a critical question because if it's not the same address, you want to hit no, and it will actually populate another line for you to input that address. And so now I'm going to switch to an interview that I've already started so you can I can sort of go through a little bit faster and show you what it looks like pre-filled.
Okay.
Stop this share and share. Okay, so this is a MAID answer and discovery form that I started filling out already, just so I can go through a little bit faster. So I'm going to skip back to the About You section so you can see what that looks like. So it seems to have erased the information I had in before. So I'm having a little bit of technical difficulty right now. Let's see.
Yeah, Jade, when you made, I think you did the same window, so that started a new session in the same one.
Okay, so you know what we'll do is just sort of run through this one really quickly. I'm just gonna put in an address so that we can move forward. Do that. Okay. So say our tenant is named Jane Doe. We're gonna say for now, there's not another tenant that was named in the eviction. So, and this question is sort of getting at that as well. It's asking you to check the summons and complaint form that the tenant received to see if there were other named tenants or occupants on that complaint. For now, we're just gonna say no. This is another critical option that MAID allows. It will actually send the tenant reminders about deadlines in their case. And so if you put in the tenant's phone number or email address, they can actually sign up to get these alerts. One caveat with that is right now during the moratorium, if those court dates have been pushed back, you want to warn tenants that even if they get a notification from MAID saying that they have to go to court on a particular day, they definitely want to call the court and find out if their case is on that day, or if they received a notice saying that their case is on a different day, or if they received a notice saying their case is on a different day, they should go by that court notice. And so now it's asking for the landlord's name, which would also be at the top of the summons. So we're going to say this landlord is called Main Street. And it asks, if the landlord is an LLC or lives in the building with the tenant, meaning just a smaller landlord. I think for this instance, you can say, I don't know. And the system will still give you the critical questions that you need to ask or answer. And so we're going to say that we don't think the landlord has an attorney. It's also going to ask in what case is in what court is your case being heard? And because I put in a Salem address, the system automatically populated Northeast Housing Court for me with the Salem session. So the system will do that for you automatically, but you still want to double check what your summons and complaint says. And it will tell you in the top left-hand corner which court your case is in, and you want to make sure that it gets inputted here as well. And it's also going to ask you for the court dates that are reflected on the summons. And so these court dates are usually reflected at the bottom of the summons. There's usually this paragraph that tells you about the date that the first court hearing will be, as well as the date that the answer is due. So the answer is usually due the Monday before the court date, which is usually a Thursday for a housing court case. It might also be a Wednesday if it's a Boston housing court or public housing case. So we're going to say the date of this first court hearing is, August 7th, or let's choose a Thursday actually. Let's make it August 13th. And what is the day that it says you must answer? So it's usually a Monday. We're going to make it the Monday before that. So Monday the 10th. All right, so the other critical thing, which I believe Quentin mentioned a bit, is that by filing an answer and a discovery request, the tenant will automatically have their first court date rescheduled, and it will be rescheduled for 2 weeks later. So because this first court date was going to be August 13th, it's actually now going to get pushed back to the 27th. Okay, so the reason for the eviction, and this is something that would be reflected on the notice to quit. I can try to pull this document up so folks can see what it looks like, but it's usually a letter from the landlord or the landlord's attorney telling the tenant that they have either 14 days or 30 days to move out. If it's a non-payment case, it would usually be 14 days. If it's for fault or no fault eviction, it would normally be 30 days. So you want to look at that notice and see why it says the tenant is being evicted. And then you would just check the corresponding box here. So for this one, we're just going to say that it's a rent case. So the landlord is saying that the tenant owes rent. And now MAID is actually going to help you select defenses to your case. This is one of the main features of MAID, is to really help folks figure out what defenses they may have. So now it's sort of asking about the housing, whether it's public housing. We're going to say yes, that this is public housing. It also gives you an option to say English is not the tenant's first language, and an option then to request an interpreter and to input the language that you need the interpreter for. So this is also a really helpful feature because this will populate on the completed forms. And so it will notify the court that this tenant needs an interpreter. So the type of subsidy, I'm just going to say public housing. When did you first move in is one of the questions it asks. Oftentimes I found that my clients don't remember the specific date that they first moved in. So this is actually like an optional question. It's not something that you have to fill in to move forward. And for the amount of rent, we're going to say 500. And we're going to say the rental agreement is in the form of a lease. Okay, so now it's asking for you to refer back to the notice to quit. So we've already selected that it was a 14-day notice. It's asking you specifically to look whether your name is on the notice to quit, whether there are other names on the notice to quit, and whether the address is correct on the notice to quit, because these are all potential defects. If any of this information is incorrect, then MAID will help you flag that as a defense to notice to quit. Okay. And then it asks specifically about the non-payment claim. So whether the tenant was behind on the rent, in fact, when they got the 14-day notice. And we're just gonna say yes for this case. The type of lease. For this case, let's say we're not sure if it's a month-to-month lease. It's asking when the tenant received the notice to quit. So for this case, let's say sometime in July. Let's actually choose 28. So the next thing it asks you to do is to go back to that summons and complaint, which is the court notice, and just to confirm that the information on that notice is correct. So one of the key things it asks you to do is to check whether the reason for the eviction that's listed on the notice to quit matches the reason that's listed on the summons and complaint. Because that's a potential defect. If the landlord says in the notice to quit that you're being evicted for non-payment of rent, but then the summons and complaint says you're being evicted because of smoking or something like that, then that's a potential defect, and MAID would help you flag that. And so now it's also asking just to make sure that the names on the summons and complaint include everyone who signed the lease and is a tenant in the property. Also that the address is correct on the summons and complaint. One defect that we see a lot with the summons and complaint is sometimes the unit number is not listed. So if you have a summons and complaint and it has the tenant's address minus their unit number, that's something where you would say no, that address is not correct. And MAID would help you flag that defense. Okay. So now it's asking you about the timing of the notices. So whether you actually received the date you received the notice to quit, the date you received the summons and complaint. So let's say we received the summons and complaint. Let's say you received it on this in the future. And it also asks how you received the summons and complaint. So whether it was mailed to you, handed to you, or taped on your door. I think we're gonna say taped on my door. It also notifies you of a key defense that the tenant has. So the fact that the tenant has a right to pay all the money that's due before August 10th, which is the date that the answer is due. And if they do pay all of that money, then the landlord cannot move forward with the eviction for non-payment of rent. So it sort of asks you here to flag whether the tenant has paid all the rent arrear. So in this case, we're just you can skip past that option if that is not the case. Now it explains sort of the defense of waiver. So basically, did any of the following happen after the date that the landlord sent the notice to quit? So did the tenant pay rent after that date? Did the landlord allow them to sign a new lease? And does the notice to quit say that the rent will be accepted for use and occupancy only? So I just want to flag that some of these terms are highlighted in green, and you can actually click on them and it will explain further what these terms mean. So use and occupancy is the name for rent that's due after the landlord starts an eviction process. So some landlords will have a notice to quit that says any rent paid after that date will be accepted for use and occupancy only. So that is important language, because if it does not say that, presumably the landlord could have waived the eviction case by accepting rent from the tenant after sending them this notice to quit. Okay, and so now it sort of it's about to go through the defenses and allow you to go through a checkbox of potential claims and defenses that you might have. Just gonna take a pause here to see. Quentin, I can't see the chat option, so I'm not sure how I'm doing on time. So just let me know if I if I'm approaching my time limit.
I think we're at about 5 minutes.
Okay, so I'm just going to go through these defenses very quickly. So you can select, whether the landlord has harassed you in some way, whether the landlord has tried to lock you out, or some other defense that you might have here. It also asks questions like, did you pay a security deposit? So let's say yes here. And it also will pre-select some defenses for you just based on the answers that you've put in already. So you can sort of go through and read the defenses that are pre-selected and uncheck any ones that don't apply. One of the critical defenses that tenants can raise in these cases are about bad conditions in their apartment. So it's going to ask you specifically whether there are any of these conditions, and you can select any ones that apply. So we're just going to say security problems. Okay. The other critical thing is it asks you whether the landlord is aware of these conditions, either because the tenant notified them or someone else did. So you want to sort of go through and figure out which of those apply. Let's skip through that. And some of these things that I'm skipping through are just additional defenses. As I said, there was a security deposit. It's asking me for the amount. And then it lists some potential violations of the security deposit laws. So if any of these apply, you would select these and it would automatically add that defense for you. Okay, one of the more important things that it notifies tenants of is the right to a jury trial. This is my suggestion to tenants is usually to always say that they want a jury trial, because this will automatically get them more time in their case. So in addition to that 2 weeks that they get at the onset for filing an answer and discovery, a jury trial is going to take at least 3 months, maybe 6 months to get scheduled. So if the tenant keeps going to court and following, whatever steps are outlined by the court, you're guaranteed to have more time by selecting a jury trial. And here the tenant can explain if there are other reasons why they should not be evicted. And it gives you some examples, like for example, I'm over the age of 60. That's a big reason, because the judge will actually have will have the ability to give the tenant up to a year in the property, even if the landlord wins at court, if that person is a senior or has a disability. And you can also add other special reasons, like, there's an issue with your child and switching school districts because of IEP. So just something else to be aware of. And so now we finished the main answer outline. The next thing it's going to ask you to do is to add discovery questions. So MAID automatically selects discovery questions for you. You can go through and see if there are other questions you want to ask the landlord, or you can just keep those default selections. And now it asks you to sign your court documents. So this is what we mentioned earlier on about being able to sign on your computer or send it to a cell phone. So I'm just going to sign this and continue. And now it asks how you intend to get this paperwork to the landlord. So you can choose a date in the future, for example, where as the date that you're going to deliver it to the landlord. So let's say we're going to deliver this to the landlord tomorrow. Okay. It also tells you that you might qualify for legal help. And if you click on this link, I believe it takes you to another form that you can fill out to get potentially a legal help from Greater Boston Legal Services. And we're loading. But essentially, it will then populate a copy of the answer, the discovery form, and a cover letter for you to send to the court. So the entire package will be ready for you to send. Here we go. So congratulations, you finished the interview. Now you have the option to click on each of these forms to download them. Let's see if we, okay, so it downloads as a PDF with this handy cover page that just tells you what's happening next in your case. It reiterates the court date, where you need to go to court, tells you what to bring to court. So this is really helpful for tenants to have. It also tells you what to do if your landlord does not respond to your discovery request. So if your landlord does not respond, it tells you by which date you should file a motion to compel, which is a request essentially asking the court or telling the court that the landlord has not answered the questions that you asked, and the court should force them to answer those questions, which is a very powerful defense and tool for tenants to have. And it also gives you information about how to do that. So this is the cover letter that it generates already with the tenant's signature and address. This is the answer form. This is what the completed answer looks like with the tenant's information and defenses. It also has that request for the interpreter that we talked about earlier. This is the discovery form. It tells you what the rescheduled trial date is going to be, which is that 2-week continuance. And these are just questions that we're asking the landlord, or documents that we're asking the landlord to produce. And separate notice for the interpreter again. All right, so this is the completed package. There's also an option to download this package as a Word document so that you can actually go through and make edits if you wanted to.
So I think, Jade, this might be a good time for us to switch it off to Stephanie to give an update.
Hi, I was just typing out a message about e-filing, which is topical. So I just wanted to walk you through some advocacy that we've been doing with the housing court to protect unrepresented litigants and their access to the courts during these unprecedented times that we're all living under this new virtual reality that we'll be embarking on. And if you too would like to join our advocacy efforts, I'm going to put our fearless leader Annette's email on the chat in a little bit, or if one of the co-trainers could help me with that, so that you can reach out and we can coordinate how you and your organization can help us push these important policies forward. So initially, we are advocating that tenants not be defaulted in the first remote hearing, right? That first remote hearing should be used to double check that everybody's on the same page on technology, that everybody has access to the court, and that kind of thing. We've gotten some traction from the housing court on that. The chief justice of the housing court recently announced that they're going to do what they're calling a tier 1 check-in at the beginning of the case. That would be the first interaction a tenant has with the court. And so we're still looking for confirmation that this will be for every single case, which is what we're pushing for, and that at that first initial hearing, tenants are going to get information on requesting an interpreter, on resources that are available to them, such as RAFT and the Tenancy Preservation Program. And I see that I have some chats on the Tenancy Preservation Program and the such before getting jumped into mediation, right? And so there's, even though we have this win that they've acknowledged that they will do a tier 1 check-in, there's still more work to be done in ensuring that that is done in the best way possible for folks to know their rights before mediation. We are also pushing for further translation and more language access to the courts. Right now, when you call most of the courts, every prompt you get is in English. Press 7 to talk to blank, press 8 to talk to blank. We need that from the get-go. Folks who speak different languages have nowhere to go, right? We do not want defaults happening because Stephanie, was calling, and I ended up connected with a district court instead of the housing court, and I couldn't let them know that my phone doesn't have enough minutes for my hearing that's happening in 10 minutes, right? That shouldn't be happening. Rather than putting a big notice up top of these documents saying, this is an important document, please translate it, we're pushing the court to actually translate these important notices, because this is not business as usual, right? We are in unprecedented times, and it calls for further access to the courts from them. Some other issues that we are pushing for are, clear instructions before and after these remote hearings. People need to know how to access it, and it's not just sending a Zoom invitation. That's not plain English enough. That's not translated in different languages, and so we need the court to assist us on that. We also, as you all just were discussing, we're also pushing for better integration between MAID and the court's filing system. Our goal is that once a tenant completes their MAID interview and their discovery, they can automatically upload it into the system. Right now, there's a separate parallel system called Tyler that